explanation for why people have a wariness on is this, that you are saying that, oh, if it's no guilty intention, then it means when you're acquitted for having no guilty intention and not having committed crime, you are meant to be acquitted, released, discharged. You cannot be kept in any kind of confinement. Whereas for the defense of insanity, what you do have is largely that if the defense of insanity is accepted, you would find that people would be, it's like the kind of finding. In England, they have a thing like where you say that, guilty by reason of insanity. They were not willing to sort of say not guilty. And you have an entire disposition procedure by which the person is not found to have committed the crime, but is not discharged, not set at liberty. So it's not just the intention, it's the fact of insanity. And what you're saying is, quote unquote, that insane people are seen to be unpredictable and hence dangerous by reason of their unpredictability. So you need to keep them in safe custody so that they are not a danger to the world at large. So if that is the prompting factor, see, there are two kinds of arguments which are put forth. One is you feel offended by the fact that you are punishing somebody who didn't intend to do something. If that is what is bothering, then there is the entire realm of saying, okay, no mens rea hence. If you're on the other hand saying that no punishment or this special route needs to be put there, because if it's just a guilty intention rule, then you will have to put the person at liberty, then the defense of insanity acquires a different complexion altogether. You could also have that because you have the defense of insanity, at the policing level, people may not record. You may not have a crime being reported. You may just be told, the parents or the family may be called and said, you please look after this fellow, it shouldn't be happening this or that way. And an entire non-formal process takes care of things. I am deliberately flagging it because it does happen. But when it gets into the system and you have a whole trial and you then acquit somebody on grounds of insanity, it's important for us to appreciate that it doesn't mean that if you are found not guilty by reason of insanity, that you're out there tomorrow. There are entire set of very executive processes by which people are kept in detention. There are reforms which have happened there, but I still feel it's important for us to understand that the defense of insanity is not some kind of a license to kill or to say, oh, you can do what you want and then go and plead insanity. It's not as simple as that. It's usually you'd find most lawyers petition for insanity when the alternative is the death sentence or a really severe life imprisonment. So the punishment to a great extent also dictates why people contend for it or don't contend for it. And because in my country we do have the sentence of death, and you find that the defense of insanity keeps surfacing back only for that reason. So in that situation, then it's important to ask, is this protection or is it discrimination? Is the defense of insanity some special protection given to people with disabilities? Or is it, what do people with disabilities gain? Why is it that somebody is willing to say that I was not myself at that point of time? One is, and this is an evidence-based thing you would find, that till you had the death sentence on the statute book in whichever country, you had many, many more petitions of the defense of insanity. The moment the death sentence went, it kind of came down. You'd also find it's generally not raised in relation to minor offenses because the consequences are much greater. You have this entire way of keeping people in safe custody and how you're dealing with them. So you can have indefinite confinement, you could be put into a higher security place, and you could be what I would say neither mad nor bad. The reason I'm saying neither mad nor bad, you go into a mental hospital or a psychiatric facility, you would find that the people who are there because they had committed a crime are in much, much higher kind of security places. On the other side, if you go to the prison, you would find a similar kind of singling out. So what is available to prisoners or to under trials as such is not available to people who have. On the other hand, you also have So that's the kind of factor I want you to just keep in mind, that if the only advantage is that the defense may cause for proceedings not to be initiated, is that a good enough advantage for us to take? So my third sort of question is that, okay, what is it the defense gives us which reasonable accommodation doesn't give? Or other defenses against culpability? I've already mentioned guilty intention. Reasonable accommodation to a large extent will also take into account the factor of, in a strict liability situation, could take into account the fact of an individual, I'm sort of saying is not just any individual, as so many of us are very bad travelers. It's like the sort of things that you land up doing when you come out of jet lag. You're disoriented. You may trip into that which is considered to be a security threat. So are we sort of saying that, all right, because of these enhanced security concerns, because of the fact that we do not want that we should be unfairly punishing somebody, is that a good enough reason to have the defense of insanity because we want to be fair? Or can reasonable accommodation accommodate that? And reasonable accommodation, the way I would see it, is that it is something which should be available to everybody at a point of time where a standardized kind of solution would not be okay. When Siobhan was making her presentation on inclusive education, one of the things that she said was that when you get people with disabilities into the system, into the education system, more than ever you recognize the fact that one size doesn't fit all. I feel a similar kind of thing is appropriate in the criminal justice system. We need to recognize the fact that as humans, we are frail people. We make mistakes. And the fact that you make mistakes, you pay for it. You pay for it in several sorts of ways, but it shouldn't mark you forever. And it's important somewhere, because I would go with the whole Senecan notion that to punish a fault in full is itself a fault. Because the moment you demonstrate that level of cruelty in a criminal justice system, if in your dehumanizing the other, you dehumanize yourself. And if the defense of insanity can be a basis for us to think more deeply on the criminal justice system, I would want to take that route. I wouldn't want us to take that simplistic kind of thing that, all right, you're asking full legal capacity, you get full culpability, how we treat everybody in the criminal justice system, you get treated the same way. My thing somewhere is that uneasiness that we have about punishing people who did not do it with wrongful intention could be a basis for us to look at our criminal justice systems in a more humane way, start to think in terms of restorative solutions. I have always held that disability rights is good for everybody. It kinds of the sort of diversity that you take into account, a sort of human vulnerability, which you also take into account, the sort of potential to be able to rise above vulnerability that you take into account. All of this is a worthwhile venture. My last slide is somewhere, okay, whenever we speak about the defense of insanity, we are primarily presuming that the wrongdoer is a person with disability and the victim is a non-disabled person. My question to you is, what if you have people with disabilities on both sides? What are you going to do then? How are you going to address it? If the defense of insanity you give to one, then are you wronging the other? If you're going to say that the victim has to be, in this case, be given priority, then what about your general uneasiness about punishing people who did something wrong without intending to do so? I think it's important for us to use this opportunity on worrying about the defense of insanity, to deepen our concerns on having a humanized criminal justice system. And if people with disabilities can lead us to it, I think this is where we should give and we should accept that leadership. Thank you so much.
Thank you very much, Amita, for that fantastic presentation. Our second presenter this evening is Dr. Charles O'Mahony, who also needs no introduction to you all. And his presentation today will be on defendants and offenders with psychosocial disability, with a particular emphasis on diversion from the criminal justice system. So thank you.
very much. Good afternoon. So I just have a slide here where I just set out the scope of my presentation. So really what I'm going to look at very briefly is defining who is eligible for diversion from the criminal justice system, and some of the terms that are used before I actually talk about what diversion is, where it takes place, the arguments that have emerged in relation to diversion that support it and oppose it, and then I'm going to have 3 slides where I'm going to look at, I'm going to pose some questions and make some observations in relation to the implications of the UN Convention on the Rights of Persons with Disabilities in this area of law and policy on diverting people with mental health problems from the criminal justice system. Okay, so in relation to this area of diversion, so what we're talking about is diverting people with mental health problems or intellectual disability from the criminal justice system. So like in a lot of the other areas that we've looked at in the other panels this week, how you define disability can be quite contentious. And I suppose what qualifies as a disability for the purposes of a diversion programme varies from jurisdiction and from different parts of the country to another in a domestic state, at the domestic level. So you might have, for example, in the UK, a diversion programme operating in Manchester that's different to one operating in London. So you have different definitions. So generally speaking, diversion programmes tend to aim to divert people with serious mental health problems from the criminal justice system. Okay, so it's very much based on a medical model. There's also an increasing issue in some jurisdictions around the criminalisation of people with intellectual disability, and particularly where services are no longer available. So this is the type of terminology that is used. And learning disability as well, people with learning disability, there's a growing focus of that as well in a number of jurisdictions. Okay. So before I talk about what diversion actually is and the arguments supporting it and opposing it, I just want to talk about I suppose a bit of a historical background to all of this, and that's the story of institutionalisation. So in a number of jurisdictions throughout the world, we've undergone a process of deinstitutionalisation. So large psychiatric hospitals in Western Europe, North America and other places throughout the world have been closed down over the last number of decades. And that deinstitutionalisation process has corresponded with an increase in the number of people with serious mental health problems showing up in the prison setting. And there's a huge body of research around this in many different jurisdictions. And this term is sometimes used to describe that process of deinstitutionalisation and this growing number of people finding themselves in the criminal justice system and in the prison. And that's known as transcarceration. Okay, there's this thing also that you come across in the literature and the research on this. It's called Penrose's Law, and that was developed in the 1930s by a researcher called Lionel Sharpell Penrose, and he came up with this theory that has been proven in a number of jurisdictions that when you decrease the number of beds in a psychiatric hospital, for example, there's a corresponding increase in the number of people with serious mental health problems in the prison setting. So you have this kind of inverse relationship. Okay, so I just want to kind of paint that kind of background for you, or to paint that picture of deinstitutionalisation and the consequences in relation to lack of community supports and people who are now being dealt with in another coercive environment, namely the prison. Okay. So if you think about it, in Ireland, this is really borne out, as in many other jurisdictions throughout the world that we've closed down. We had, at one time in Ireland, over 20,000 people, the largest amount anywhere in the world, per capita, of people involuntarily detained in psychiatric hospitals. Okay? And we had a very small prison population when we had psychiatric hospitals and other places of confinement and detention. And what we've seen in Ireland is that once we've closed down these large psychiatric hospitals, we've seen a dramatic increase in our prison population. And there has been research that shows that there's this connection between the two different systems. Okay, so when does diversion take place? Well, diversion really, I suppose, as a policy, has developed as a response to this overrepresentation of people with mental health problems, psychosocial disability, in the prison and in the criminal justice system. So there's a recognition internationally that there is an overrepresentation of people with mental health problems, mental disorders, if you choose the medical terms, and that's very clearly shown in the research throughout the world, and that's a problem. And there is a sense that you need to address that problem, and diversion has developed as a way to address that problem. Okay, so I'm sure many of you in your home jurisdictions will be aware of diversion policies. So diversion can take place at a number of different points in the criminal justice system. So it can happen actually before you arrest somebody. So it can happen in the community informally. It can happen in police stations following somebody's arrest on the suspicion that they committed a crime. It can happen before somebody goes to trial. So, for example, there could be a prosecution policy not to prosecute somebody subject to certain criteria. You can also have diversion at the court stage, and indeed in some jurisdictions, particularly in North America, there has been the emergence of mental health courts, which take a problem-solving approach, in theory, to dealing with people with mental health problems coming before the courts, so specialist courts. You also can have diversion provided for at sentencing, so somebody's convicted of an offence and that they are diverted to services, to psychiatric services. So what I'm trying to say here is that diversion actually, it's very complicated, it's very complex, it varies from jurisdiction to jurisdiction, and there's no model really of best practice. It's very local very often in different states. Okay. So really what diversion involves is a range of processes and schemes. Sometimes these are provided for in law, other times they're not. So there's no legal basis for them. And really the whole purpose of them is to take people out of the criminal justice system. So it's really taking a broad approach to understanding that there is a complexity and a number of different ways in which you can divert people out of the criminal justice system. This is actually quite a big problem. So if you look at the research, whether it's in Africa or North America or in Europe, there is a clear evidence base for this overrepresentation of people with mental health problems in the prison population, when you compare that to the incidence of mental health problems in the general community. So there's a clear evidence base there. And if you look at the World Prison Population List that's published annually, the most recent one for 2016, you can see that there are over 10 million people in prison throughout the world. And that's very problematical because the research shows that there is a very high rate of detention of people with mental health problems in the prison population. So there's a lot of people embroiled in the criminal justice system. Okay, so there's a lot of arguments in support of diversion. Okay, one of the arguments that you can read very often about if you're reading this area is that people with mental health problems are often discriminated in getting bail. So when they're charged with an offence and the judge makes a decision whether to release them into the community awaiting trial, very often the research shows that people with mental health problems, psychosocial disability, they don't get bail. They're discriminated against. And actually the research shows then if you don't get bail, you're more likely to get a custodial sentence. So you're more likely to get a prison sentence if you're convicted. So diversion is one way in which you can address that kind of discrimination people face. The prison environment is also very harmful to everybody, really, but it's very harmful to people with psychosocial disability in particular, and there's an evidence base around that. Very often substance abuse is very rife within prisons, and really diversion has emerged as a way on which the law can act as a therapeutic agent, so a problem-solving approach in where you can identify the reasons why somebody's engaging in criminal behaviour and give them support. So this is the argument for it, to connect people to services and support to help them address the causes for their offending behaviour. Okay. The research also shows that people with psychosocial disability are at increased risk of HIV/AIDS, contracting sexually transmissible diseases, TB, at increased risk of sexual violence, drug misuse and suicide in the prison environment. So this is the reality, and the research supports this. So there is an argument that diversion is important to avoid these poor public health outcomes for people with psychosocial disability. Also, the consequences of imprisonment are particularly acute for people with psychosocial disability. So they receive, because they have a criminal record, they've served a period of time in prison, in conjunction with and having a psychosocial disability, and there are restrictions in relation to social housing, employment, education opportunities, eligibility for jury service and political participation. So there's this argument that diversion is positive in that it can avoid some of these additional barriers that people with psychosocial disability face as a result of a prison sentence. Okay, so there have been arguments against diversion for many years. Now, a lot of those arguments against diversion have been based on the notion that it's not maybe effective. You know, there's no evidence base. Very often they don't do cost-benefit analysis to see our diversion program is effective. Also, you can have a net widening effect, so that these diversion programs can be coercive and they can actually be discriminatory. So you have a greater involvement, a longer involvement with the criminal justice system, because in mental health court you have to comply with it. It can be very coercive. It can force you to take medication, for example, in the community. And if you don't complete it, then you have to serve your prison sentence. So there's disadvantages with some of these diversion programs. But what's interesting is that in light of the CRPD, there is additional criticism and very justifiable and correct criticism of some of these diversion programs throughout the world. And that's because they're very much based on the medical model. So the debate up until the CRPD was care or custody. So either you were imprisoned or you were given medical treatment. So the debate, that debate now is very much criticised because it's based on coercion, forced treatment, a requirement to take medication in order that you don't go to prison and you can perhaps be in a community setting, or that you might have to actually be a resident in a kind of a care setting, a psychiatric hospital type scenario. So if you look at the CRPD, and if you look at some of the conversations that we've had about the rights in the CRPD this week, you'll see that these types of processes that are coercive, they violate Article 12, the right to legal capacity, Article 14, the right to liberty, Article 15, the freedom to be free from torture or cruel, inhumane and degrading treatment. That's particularly important because the UN Special Rapporteur on Torture has indicated that in certain circumstances, forced psychiatric treatment can amount to torture. And that is very often a requirement of participating in a diversion programme. And also integrity of the person under Article 17 and Article 25, the right to health. So clearly, these coercive elements within diversion programmes are now clearly in violation of the CRPD and our emerging understanding of what these rights contain. Amita referred to reasonable accommodation, and I would say that my own view is that these diversion programmes, if they're reorientated, they're not coercive, that there's choice in relation to how you're diverted from the criminal justice system, they can comply with the CRPD. And we can look at these diversion programmes as a type of reasonable accommodation. I can talk maybe a little bit more about that later on. So really, just to conclude then, in relation to some observations and questions I'm going to pose around this kind of complicated and contentious area, is that potentially there's millions of people throughout the world that are affected by this. So people with mental health problems, psychosocial disability, that are being embroiled within the criminal justice system. And there is an increasing discourse which criticises diversion in light of the CRPD. And we need to be very vigilant as we challenge institutionalisation of people with psychosocial disability, that the state doesn't use this as an opportunity to move people from one setting, an institutional setting, into the prison setting. I think we have to be very vigilant around that. We really need to understand the complexity of diversion and the different types of diversion programmes that operate throughout the world. There's no one best practice, and some diversion programmes are better than other diversion programmes for respecting and supporting people. One of the things that would strike me from researching this area and talking to people with psychosocial disability is that very often people who are vocal on this from the CRPD perspective and that are engaged with it are people who have experience of being involuntarily detained in civil commitment procedures, so in general psychiatric services within the hospital setting, and not necessarily people who have had experience of being having psychosocial disability and being in prison. So I think it's very important that the voice of people with psychosocial disability who have been embroiled in the criminal justice system, who have been in prison, that their voice is represented in the debate around the CRPD and diversion. Mental health courts and other processes of diversion, like I said, we should see them as evolving models of practice, and we should critique them in light of the CRPD and really question things that are very coercive and that force people to take treatment or medication in the community. Okay? And I think really state parties to the CRPD need to engage in reviewing any kind of diversion programme in light of the CRPD. And my view is that it is possible to look at critically diversion in light of the CRPD and make it more responsive and use it as a form of reasonable accommodation to support people with psychosocial disability to live in the community and to avoid prison in certain circumstances. So just to conclude then on my last slide, really the CRPD is, in a way, it's really a useful tool to critique, and we can use the various different articles that I have here as a way of looking to improve diversion and to make sure that it isn't coercive and it doesn't violate the rights of people who have really very no choice very often. It's either prison or the diversion programme, so real choice for people, and we talked about that this morning. And I really think it's very important as well, and this is the last point I'll make, is in relation to disabled persons organisations. I think very often disabled persons organisations, they don't engage with, and certainly my experience in Ireland, with issues around reforming the criminal law and criminal justice policy. Very much the experience in Ireland and elsewhere has been focusing on civil mental health law, and that there are more, I suppose, contentious issues around this area. And I think it's very important that disabled persons organisations, human rights organisations engage with these issues and that they advocate for the rights of people with psychosocial disability embroiled within the criminal justice system. Thank you.
Thanks very much to Charles. Our third speaker now will be Ms. Donna Sheinbaum. Apologies if I've pronounced that incorrectly. Who will be speaking about Mexico and challenges and opportunities and access to justice for individuals with psychosocial disabilities. Thank you.
Should I turn the light on the film? Okay, perfect. This one, no? Do you want to show the video now? Yeah. O sea, in a couple of minutes. I'll do it. Hi, my name is Diana. I'm from Mexico. I'm very excited and grateful to be here. And a lot has been said about the power of communication, and I think communication is very, very important in the criminal justice system. So I want to show you a very, very short film. Please don't fall asleep. It's just 1 minute. Hoping that it's a very powerful tool for you to communicate what happens in Mexico. My name is Miguel. I was sentenced to 5 years in prison. The prosecutor did not let me testify. I was not allowed to be present during hearings. I never saw the judge or my lawyer. I was not given the possibility to defend myself because I have a psychosocial disability. So I wish I could stop here and just talk to you about this, but I'm afraid that if I do, I won't be invited again. So I just I will go to my presentation. Sorry. So what is Documenta? Documenta, it's a Mexican NGO that has been trying to understand that barriers faced by individuals with psychosocial and intellectual disabilities in the criminal justice system, and to think about alternatives to overcome those obstacles and make the criminal justice system more accessible and inclusive. We work around 4 main strategies. Litigation, we represent cases of individuals with psychosocial and intellectual disability. We do research We do training mainly of judicial staff, but also NGOs on the rights of persons with disability. And as you see, we produce audiovisual materials, short films, video blogs, everything that can reinforce our advocacy efforts. And today, I want to talk to you about what happens in Mexico when a person with psychosocial and intellectual disability is accused of committing a crime. And probably I would ask for you to think about what happens in your own countries and to think about this together. I'll be talking about Arturo's case. Arturo he's in his 20s, and we represent this case a couple of years ago. Arturo was arrested by the police in 2011. He was accused of stealing a car. The police just saw Arturo close to a car. They detained him. They took him to the prosecutor's office, and he was detained for a couple of days there. I just want to make a brief pause to tell you that in Mexico, police rarely identify the existence of a disability and are not trained to deal with individuals with psychosocial or intellectual disability. So after Arturo arrived to the prosecutor's office, he went to have a general examination that took 15 minutes. It's a very general assessment. And there was no identification of any disability. Sometimes these general physicians recommend a psychiatric examination. But in this case, Arturo didn't have a psychiatric examination. And after that, his mother arrived after several hours to the prosecutor's office. And he said that Arturo had been previously diagnosed with an intellectual and psychosocial disability. So what happened after that? Well, two things happened. First, the police changed their testimony. They said that, the mother said that Arturo didn't know how to drive also, right? So two things happened. The police changed the testimony and said that Arturo didn't steal the car by driving it, but by pushing the car. And second, that Arturo, what happened was that Arturo was examined by a psychiatrist and was declared inimputable. And I will talk about this term later. So psychiatric examinations are a turning point in the pathway in the criminal justice system for individuals with intellectual and psychosocial disabilities. These examinations, which usually take place at a psychiatric hospital, they are like 30-minute assessment, respond to two main questions. One, is the person capable of understanding the criminal nature of his or her actions? And two, is the person able to testify? So this medical opinion on the ability to understand or testify will have very pervasive effects. For one, if the psychiatrist finds that the individual is not capable, that will lead to a declaration of inimputability, which entails, as we'll see, being deprived of your legal capacity. So what does being an imputable means? Well, the legislation, the criminal code in Mexico, defines that an individual is inimputable when at the moment of committing the crime, he or she is not capable of understanding the legal nature of the actions or the consequences. This is a legal code from, these sentences from 1931, as you can see. So inimputability is not just, it means both. To be not guilty by reason of insanity, but it also means to be unfit to stand in trial. So that's why I find difficult to talk about it in English, because I think it adds both things. When Arturo was declared inimputable, he was submitted to the special procedure for inimputables. And what happened then? Well, he was deprived of his legal capacity. He became an object for treatment during the whole criminal process. He was deprived of the right to appoint his own lawyer. At some point, the mother wanted to change lawyers, so she asked Arturo to sign a form, and the judge said that Arturo was inimputable, so his signature was not valid. All decisions were transferred to someone else, and he was neglected the right to be heard by a court, testify, or even be present at the hearings. The only proof presented in this case, were the police testimony, so he wasn't there to contradict them. And he was sent to specialized prison that exists in Mexico City to comply with a pretrial measure until he was sentenced. And here I want to make a brief pause to tell you that in most cases what we have found that these pretrial security measures, medidas de seguridad en español, the length of these measures are larger than in regular cases because they wait for more psychiatric examinations. And for example, in Mexico City, we have one psychiatrist for all the public defense office. So they have to wait like 6 months for a psychiatric examination. And until that happens, people are in prison. So that's something to consider, right? Recently, I was at a hearing where after 5 months of pretrial detention, the defense asked for 2 more months because she couldn't find an specialist to do an evaluation. So that tells you about what little value has the right for freedom for these individuals, right? Even for their lawyers. So Arturo was sentenced to 4 years in a specialized prison, and I don't like numbers, but I think they're very, very important. We reviewed data from January to April, just 4 months, of people that receive a criminal sentence, and we found that from 4,500 in total, 99% followed the regular procedure, and 95 were convicted, and 5% were absolved. Of the total, 34 were declared inimputables. All of them were convicted. And then we say, okay, let's analyze what were the crimes, right? Probably all the inimputables were doing like terrible crimes. So we said, let's focus on robbery. 66% of people in these special prisons are there for robbery. From almost 2,700 in total, that are accused of committing robbery, 99% follow a regular procedure, 96% were convicted, 4 absolved, and in imputables, 23, all of them were convicted. So this tells you a lot about how our criminal justice system treats people with intellectual and psychosocial disabilities. What happened when you're declared inimputable? What are your options? What are the sanctions that exist in our criminal system? Well, there are 2 options. One is treatment in a specialized institution, that is prison, and the legislation says until you're cured and should not exceed 70 years. The other option is treatment in liberty, but under the custody of your family. And in both cases, you have to guarantee that there's pharmacological treatment, so there's obviously a medical approach. And if you are in a prison, once that the measure finishes, someone has to go and pick you up. Otherwise, you'll be institutionalized again. So you must spend more time in prison, and you'll go to a private institution, usually with no regulations, or to a government institution that the special rapporteur of torture, when he visited Mexico, he said that the conditions there were tantamount to torture and very undignified. On 2014, there was a reform on the National Criminal Procedure, and I want to tell you what changed. Well, now the legislation uses all the correct words. It refers to right to equality and not discrimination. In the case of person with disability, reasonable accommodations must be provided throughout the process. It eliminated the special procedure of inimputables. Now there's a regular procedure with specific accommodations. So obviously there are a lot of space to do better, but I think this new legislation provides a window of opportunity that Documenta has tried to benefit from that. So now we have a pilot program, and we are trying to advocate and provide accommodations within the criminal justice system for persons with intellectual and psychosocial disability. We do that through a team of facilitators that provide for these accommodations. So we think that this strategy, being there in the criminal justice system, can make a meaningful impact on the way judicial practices take place. We thought that this pilot program has been in place for 3 months, and we actually thought that we have one request for a facilitator each month, but we we have had 20 requests. And what I can tell you, what we've seen in very general terms, is that inimputability, right, still is there. It's a medical rather than judicial determination. It's based on a psychiatric examination, and this psychiatric examination has a very low standard. It's a 30-minute assessment that determines what happened to you and brands you forever. Security measures have no change, the same. It's prison plus psychiatric. We are in a prison, but you're receiving forced psychiatric treatment, and you have a lot of obstacles to be released. And the opportunity is there in accommodations, right? Where we can think there are relevant impacts we can achieve. So some of the outcomes of this pilot program. Well, first, judges and other judicial staff have a lot of doubts and need orientation about the implications of the disability in the process, and we think being there can solve some of them. Providing support through a very difficult and extremely hostile process is something that facilitators are doing. I think this doesn't have to be related just to disability. Being there in a criminal hearing is very, very, very stressful, and it's important to have somebody there that explains what is happening there and that provides support. The person participates in the process in equal basis, leveling the play field. As you see in the case of Arturo, no one was there. Like the balance was like this, right? There was no one. He had a public defense lawyer, and he had to rely that the public defense is going to do a good job. He didn't, but and the person is right at the hearing, and we make sure that their opinions and questions are listened to and are answered to. All judicial staff, everybody that is at the hearings, the police, the lawyers, the prosecutor, the judges, realize that the legal participation of a person with disability is something possible. And it definitely has reduced, in the hearings that we've been at, it has reduced the barriers in the criminal justice system, and also the stereotypes, mainly about danger. I have to tell you, when we are at the hearings of persons that have committed, I don't know, manslaughter, homicide, manslaughter, we arrive there, and there are 10 police officers, and you arrive and you say hi to the person, and you say hi with your hand, and policemen are very afraid of what they're going to happen. The defense lawyer is happy that you're going to sit between the defense and the accused person. He's really happy about that. And he actually tells you, like, be careful with your pen. So when you treat someone with dignity, and I think you achieve to humanize a very dehumanized system. So I think dignity is reachable, and this is what we're trying to do. Hopefully we can talk more about it. Thank you very much.
Thank you, Diana. Our final speaker is Professor Shane Kilcommins from the School of Law at University of Limerick, and he will be discussing access to justice for persons with disabilities as victims of crime, I believe, so a different perspective.
Thank you, Donna. Good afternoon, everyone. Just to start with, just to say to you, my area of expertise is really in the area of penology, and I'm very interested in the way in which, we have known different stakeholders in the criminal justice system differently at different points in time. So I'm always very interested in mapping how, the epistemic shifts that have occurred. And in 2012, while I worked in UCC, a colleague in a different department came to me and said, I've got this project with the National Disability Authority, and you're a lawyer, so you're interested, you know about evidence in criminal law, will you come on board? And it was a fantastic project to become involved in, but it also revealed to me for the first time, and I'm embarrassed to say this, but in teaching evidence or teaching criminal law, I often glossed over many of the issues that were really, really important, and it's only when kind of looking at it through a new lens for the first time in this National Disability Project that I began to see some of the assumptions and, that I had, and, how unfair they are in the system. So I'm going to take you through a couple of steps on this. And so I'm going to start in very broad terms, just talk to you about the victim in the criminal justice system. This is in general terms. So, in the 17th and 18th century, the victim was, in common law countries, the victim was the key decision maker, principal decision maker. They gathered the evidence, presented the evidence in court. And so they made all the decisions up to guilt determination. During the 19th century and for much of the 20th century then, what really emerged was a state-accused model of justice. And that became the dominant discourse. And I'll talk to you about that in a moment as well. And over the last 30 years, what we're seeing is a kind of a transformation where the victim is beginning to re-enter the criminal justice system. And that's happened for a variety of reasons, including, the emergence of victimology as a discourse, the women's movement, victim activism, rising crime rates. I think the law has been an important steerer of reintegration as well. And then in different domestic countries, different issues that have arisen. And so the victim is re-entering the criminal justice system. And so just want to highlight at this point, there's a criminologist by the name of Professor Nils Christie, Norwegian, and he talked in 1986 about the ideal victim. And he spoke about 5 different criteria which were important in that respect. And 2 of them were as follows. One was perceived vulnerability, and the second was perceived weakness. And so one of the things that struck me as well, if there are ideal victims, and I know this is a generalization, what would that mean for persons with disabilities? And one of the things that I've discovered is that, as victims proceed through the criminal process, and particularly when they hit the institutional phases of that process, the pre-trial, trial process, that their perception is far from ideal. And I'm going to talk to you about that for a few moments. So, if I had more time, I'd like to mention something about Article 16 that I think is interesting, just around the recovery issue, but I'll come back to that. So, just in terms of steer of integration, and I want to show you how different issues collide. So, one of the first cases in Ireland which recognised victims of crime was a case from 1988. It's called the People DPP versus JT. And so the story of this case is that a mother and her daughter were sitting down watching television one night. Daughter was a 20-year-old young woman, and the programme was about incest. It was a drama. And at the end of the programme, she was quite upset, and she turned to her mother and she explained that her own father was perpetrating similar type of offence on her. And so a prosecution was brought. And the husband in the case, the defendant, he objected to his wife giving evidence and he objected to his daughter giving evidence. And he objected on the following 2 grounds. He said, my wife cannot give evidence against me because there's a common law rule which says that she's my spouse and there's only 2 circumstances when she can give evidence for the prosecution against me. That is if I perpetrate a sexual offence on her or if I perpetrate physical violence on her. So in neither instance does that occur, so she can't give evidence against me. My daughter has a disability and therefore she's incompetent to testify. So neither witness can testify against me, and he was hoping that in those circumstances the case would collapse. But the judge in the case, Mr. Justice Brian Walsh, he looked at it and he said, well, yes, you have your fairness of procedure rights under Article 38 of the Constitution, but we also have the family right protected under Article 41. And whatever common law rule existed regarding a spouse being able to testify only in those limited circumstances, I strike that down having regard to Article 41. So in those circumstances, the spouse was permitted to testify and he was convicted. But it's kind of seen as the first case that really identified victims in the criminal process. Now, there's not a direct express provision. It was through Article 41, but it shows you the types of issues that are arising. And so since then, we've had what I might call the juridification of new form of inclusion, in the sense that we've had a lot more provisions being introduced, particularly since 1992, that recognise victims in general. And one that I'm going to come back to in a moment again is live television links in the courtroom. So really that's just from the Criminal Evidence Act 1992, which permits a witness to give evidence, but not in the same room as all the lawyers and the judge and so on. So it's live. It's like me giving evidence here, and it's being piped down to Cork. I can be cross-examined on it. It's viva voce, but I'm just not in the same physical room, and that's permitted in certain circumstances. So a whole range of different provisions that have been employed to accommodate victims of crime. And one that's become very important is kind of victim impact statements. And that has been augmented and supported by EU directives and so on. The most recent is the Victims Directive, which is calling for increased provision around 3 different pillars: participation, protection and information. Ireland is responding to that through the Criminal Justice Victims of Crime Bill and also through the enactment of the Criminal Law Sexual Offences Act 2017. But just one other issue just to be mentioned at this point is that the European Convention on Human Rights has also been very important here. And again, although there is no express provision for victims within that text, Articles 2, 3, 6 and 8, the judiciary have been reading into that protections for victims of crime on a whole range of issues. Okay. So one other issue just very quickly to mention is that we're also beginning to see increased accommodation for victims of crime in general through the civil process. So, removal of the statute of limitations for sexual abuse cases, the introduction of new torts such as grooming, a new tort of grooming being introduced by the courts in 2015. But let's look more specifically now at victims with disabilities. And I'll start with the Ryan report from 2009. And so this was a report which documented, it looked at the carceral archipelago that existed in Ireland in the 1950s and 1960s and the range of institutional abuse that had taken place in those institutions. But I just want to read a quote from you, and this is from, as I said, 2009, but it's looking at child abuse in institutions from 1936 onwards. And it noted that children with learning disability, physical and sensory impairments, and children who had no known family contact were especially vulnerable in institutional settings. They described being powerless against adults who abused them, especially when those adults were in positions of authority and trust. Impaired mobility and communication deficits made it impossible to inform others of their abuse or to resist it. Children who were unable to hear, see, speak, move, or adequately express themselves were at a complete disadvantage in environments that did not recognise or facilitate their right to be heard. And so, from an Irish perspective, we've become, much more, this has really been a conscious reason, we've become much more aware of those type of illegitimate hierarchies of power and the type of abuse that occurred. And so you would expect from that then that, you would see a, profound change in our approach to dealing with issues of this kind. And so I'll just take you along now again and say, okay, in 2010, we introduced a Victims Charter in 1999, and we amended it in 2010. And so these are the commitments that are made by all of the criminal justice agencies in the state to victims of crime. But what I think is significant just to begin with is that only once, and only by one agency, are victims with disabilities recognised. And that's in page 17, where in the Garda section it says, if you have any form of disability, we will take your special needs or requirements into account. So that's one issue showing the kind of gaps that exist. And so the next issue, and again, I would have read this previously, not looked at it, would have glossed over it from a legal perspective and thought it was fine. But this is a statement of general guidelines for prosecutors, which was a book published in 2010. And what it's documenting here is the reasons why you would not prosecute. And paragraph G here says, could the reliability of evidence be affected by physical or mental illness or infirmity? Paragraph N, in relation to mentally handicapped witnesses, are they capable of giving an intelligible account of events? And it goes on then to link it in with giving unsworn testimony. So just adding to that, the statistics that we have in Ireland looking at these issues. So there was a study done here by Bartlett and Mears, I think they were both based here in Galway. They identified a number of problems, when they talked to victims with disabilities about the support services available. One of the issues they highlighted is the amount of underreporting that takes place in sexual abuse cases. So 66% of the persons with disabilities they spoke to who suffered sexual violence and attended rape crisis centres in Ireland between 2008 and 2010 did not report the abuse. So real issue about underreporting. And then in other reports we're beginning to see not only is there an issue about underreporting, there's also an issue of attrition rates. So in a study done here by Hanley, again based out of Galway here, looked at 78 complainants who again may have had a disability. Of those 78 cases, only 2 were prosecuted. So that's prosecuted as opposed to convictions. And again, findings of that kind were confirmed or corroborated in other studies done in the DPP's office. So what you're beginning to see is not really being identified in policy literature, issues around underreporting, issues around attrition rates. And then we have the issue about, well, what about our laws itself? I think it's interesting that, in the first speaker here today spoke about insanity. When we think about the legal burden of proof and the evidential burden of proof, the only defences in Ireland that require an accused to discharge a legal burden of proof, that is on the balance of probabilities, is in relation to insanity and diminished responsibility. In no other offence, and for no other defence does the accused have to discharge such a threshold of proof. But again, in this case, under and over criminalisation, the only specific offence that existed at the time, this is until 2017, in relation to offences committed on a person with a disability, was Section 5 of the Criminal Law Act 1993. And that over-criminalised, but it also under-criminalised. And one of the reasons why it under-criminalised was that it related only to acts of buggery or acts of sexual intercourse. So it didn't cover the broader range of sexual offences. Nothing was done about this. The Law Reform Commission in 2006 identified the issue of under-criminalisation and also over-criminalisation. And in 2010 we have a case where we call it a Section 4 rape. It's the act of performing, this is where the accused party was accused of inducing a woman with an intellectual disability to perform oral sex on him. And the case collapsed because there was a lacuna in the law. And you can see, the judge, Mr. Justice White, saying, "Seems to me that the Oireachtas, which is the Irish legislature, when they introduced the 1993 Act, did not fully appreciate the range of offences needed to give protection to the vulnerable." The Incitement to Hatred Act 1989, it doesn't include disability. The study that I was involved in, which is led by Dr. Claire Edwards, we noted that there is no data gathering of victims with disabilities. And that means that they're hidden or invisible in the broader victim constituency. And then we move on to the trial process. Perfect. And so one of the things as anybody who's familiar with the common law system is that it emphasises adversarialism. And adversarialism is a little bit like the grammar of a language. We all know what it is, but it's rarely articulated. And the issues that become important in terms of adversarialism is the principle of orality, that you have to say it in court, lawyer-led questioning, the observation of the demeanour of a witness, the curtailment of free-flowing witness narrative, confrontation, and robust cross-examination. And so it's a morphology of contest and combat. And the issues that become important here are consistency of account, clear and accurate recollection, accuracy as to detail, appearance and deportment, and poised expressions and body language. And so this can be, and studies, there's a really good Home Office study done from 1996, which explains that, this can be a really significant discriminatory barrier, particularly in terms of long-term memory recall, communicating information and cognitive overload, and particularly the issue of acquiescence. And so what we've seen, and I'll skip on, the issues that have become really important in that is that very often, and I think Inclusion Ireland has spoken about this, is that lots of cases collapse in Ireland because we can't get beyond this issue of adversarialism, and many witnesses are deemed incompetent to testify on that basis alone. And so I'm running out of time, but I think that there are significant amendments to the law have been made in England and Wales, particularly around the competency to testify requirement. They're moving a lot more also in the direction of ground rule hearings. And there's a recent case in England, the Crown versus Lumbemba, which is looking at this and is really emphasising the best evidence rule and the opportunity for people to give that evidence, no matter what the circumstances. And also in placing restrictions on the advocate and the way they put their cases. We don't have that yet in Ireland, but hopefully in the near future we'll see more reform, particularly around the rule in respect of competency to testify. Thank you very much for listening to me.
Thank you, Shane. So I think we have a good few minutes now for questions, if anyone has any questions for any of the speakers.